Our speaker today is Michael J. Bedart. Michael is the managing partner of Chernoff, Bedart, Echeverria, Bentley LLP and leads the HMO litigation and property causality departments. He has developed his firm's health insurance practice by successfully prosecuting bad faith disputes against insurers and HMOs. His inexhaustible efforts were showcased in 1999 with the landmark $120.5 million verdict against Aetna over its refusal to pay for care recommended by the health plan's own in-network physicians. It was the largest jury verdict ever rendered against an HMO. In the years following, he has prosecuted hundreds of medical insurance bad faith claims against all of the major HMOs in California. Last year, he avoided arbitration and obtained a jury verdict of $28.2 million against Kaiser for a cancer patient who was repeatedly denied an MRI, resulting in a reported appellate decision in Rom v. Kaiser. I will now turn the call over to our speaker. Please go ahead.
Good morning or good afternoon, depending. This is Mike Bedard, and I'm joined here today by my partner, Danica Crittenden. I wanted to begin by saying that I learned from the list of attendees that many of the attendees are non-California lawyers, and I want to, from the beginning, indicate that our practice is limited to California. So the case law that I'm going to have on this presentation, most of it is from California, and I apologize that I didn't know who the attendees were going to be, and even if I had, I wouldn't have been able to do a full, exhaustive analysis of how this case law may be different in other jurisdictions, but I'll leave that up to you folks. I do believe that at least the beginning segment of the presentation, I'm going to try to start from the general and then go to the specific. And if you practice in any jurisdiction which recognizes the tort of breach of the implied covenant of good faith and fair dealing in the insurance context, then my hope is that the things that we'll discuss today will be of benefit to you in prosecuting claims against what we commonly refer to as HMOs, which was the acronym for Health Maintenance Organization. And of course, for those of us who practice in this area, we think that it's kind of a benign term, the health maintenance. We think that it really hasn't been much of a contributor to the maintenance of health and more interfered with health. But be that as it may, in California, what we commonly refer to as HMOs are under our statutory scheme under the Health and Safety Code called managed, healthcare service plans. So let's then begin and start at the beginning, the origins of what we commonly refer to as bad faith, more properly known as the breach of the implied covenant of good faith and fair dealing. And the reason I want to start there is because the entire balance of the entire discussion is driven by our understanding of that and why it is that the tort exists in the first place. And here in California, at least to my knowledge, I believe that the first time that the common law came into existence and recognizing tort remedies arising out of an insurance contract was here in California in 1957. And it arose not in the context of a health insurance policy. In fact, it arose not out of an expressed policy provision at all, but rather out of a case involving the duty to settle a third-party liability claim in an automobile policy. And so, at least in California, the seminal granddaddy decisions forming the basis for the tort of bad faith in California arose out of failures to settle third-party liability claims. And the notion, and this is probably elementary to anybody who signed up for this program, because you no doubt already have an interest and a background in it, but just to make sure we're all on the same page. The notion which gave rise to the tort of bad faith was the fact that the insurance company and insured relationship was a special relationship. And the reason it was a special relationship and deemed so by the courts was because of the fact that unlike any other product in the marketplace, it was a relationship where on the premiums being paid by the insured was consideration that was given up at this moment of payment, and in return there was nothing at that moment of any tangible utility in exchange. So unlike any other product in the commercial marketplace, whether it's a gallon of milk or an automobile or a television set, the purchaser is getting something of utility or of value right at that moment, something you could use. By contrast, the courts recognize that an insurance policy is a bunch of promises in writing which are given by the insurance company for whatever the peril being insured is, whether it's health insurance, homeowners insurance, life insurance, disability insurance. Every single circumstance of insurance is simply a promise by an insurance company to do something in the future in the event the insured against peril occurs. In other words, you don't buy health insurance in hopes that you're going to get breast cancer, or you don't buy homeowners insurance in hopes that your house is going to burn down. And so that's a fundamental distinction between the normal product in the marketplace and the insurance product. And of course, all of the cases, and those cases in other jurisdictions that I've read, many of which follow our early California cases, all talk about the same things. Part of the reason for having these special remedies and the special duties that then relate to the conduct of an insurance company recognize that these are always contracts of adhesion that are given on a take it or leave it basis, that there is vulnerability on the part of the insured by comparison to the insurance company, that the insurance company has superior expertise, it's unequal bargaining position, and that the insurance policy product is not purchased by an insured seeking commercial advantage. You're not buying something in hopes to sell it for more later or to gain any commercial advantage. You're buying it, throwing it in the top drawer or the safe, and hope that you never need it. So I know it seems very elementary, but I think it's important to bear in mind, because then we have to follow the progression of the law having to do with the application of this tort to a first-party setting of a premium-paying insured for health insurance. And I think it bears noting that originally, when the first cases were coming out in California and the jurisdictions following California's lead on this tort, health insurance was that. It was indemnity coverage. It was where you went to any doctor of your choosing or any hospital of your choosing. You incurred an obligation in your own name, and then you turned over the bill for payment to an insurance company, a health insurance company, for indemnity. In other words, no, the insurance company was not at all involved in the decision of where you obtained your benefits, where you obtained your health coverage. And it wasn't until later, with the advent of managed care in the mid-'70s, and then the huge market penetration that took hold in the 80s and 90s, where now these so-called healthcare service plans, or HMOs, or managed care companies, began to now set up systems where they were not only indemnifying for the cost of medical care. They were, in fact, providing the medical care through a network of providers with whom they had contracts. Enhanced managed care. In California, for example, the next slide says health insurance policies and managed care plans. Again, depending on what jurisdiction you practice in, it may or may not be like that in California, but in California, only part of these policies are governed or regulated by the insurance code and the Department of Insurance. The so-called group managed care plans are regulated instead by the Department of Managed Health Care, which in California only came into being during the Davis administration, and prior to Governor Davis, it was regulated by the Department of Corporations. And of course, the law that applies is not the insurance code, but rather the health and safety code. And so, because of that, what we experienced in California going into the late 90s and beginning in 2000 was still an argument by these HMOs that the tort of breach of the implied covenant of good faith and fair dealing didn't even apply against these companies, and that you were not entitled to tort remedies because the mantra was, Your Honor, we're not an insurance company. We're not regulated by the insurance code or the Department of Insurance. We're regulated by Health and Safety Code and the Department of Managed Health Care. We're not an insurance company. We're not engaged in the business of insurance. So on one hand, they would say, you can't sue us as medical providers because we're not doctors. We're not engaged in the practice of medicine. Every HMO will tell you that. They would also tell you that they're not engaged in the business of insurance. And so they wanted it both ways. The reality is they are engaged in both. And as we'll go through it. Then the next slide is the one entitled HMOs are engaged in the business of insurance. So here in California, and for anybody not in California, it may be useful reading if you don't have an equivalent case yet, reported case. This was our case that we handled here after the Aetna, the Goodrich versus Aetna verdict that the young lady mentioned at the beginning, which the law was still in flux at the time. In California, we didn't have any definitive holding that, in fact, a healthcare service plan was, in fact, engaged in the business of insurance for the purpose of the tort. Well, that came to an end with Smith versus Pacific Care, and the citation is there on the screen. And that case actually arose out of our allegation that Pacific Care had failed to comport with the arbitration disclosure requirements under California law, which we're going to get to later in this presentation, but also having to do with why it was that they were, in fact, engaged in the business of insurance. And then shortly thereafter, we have the United States Supreme Court decision that cited their Rush Prudential HMO versus Moran. So since then, at least in California, there is no longer any debate but that the so-called HMOs are engaged in the business of insurance. And, of course, our position is, well, they should be, because if the reason that the tort exists in the first place, and in California, that the remedies for that tort are the compensatory damages, the benefits of the bargain of the insurance contract, driven by the coverage in the four corners of the contract, which in California is called by statute an evidence of coverage and disclosure form. So when you see a reference here in the slides to an EOC, that's just another way of saying insurance policy. That may vary from state to state as well. But you have the benefit of the contract, you have emotional distress damages, and you have punitive damages. So enhanced remedies from traditional breach of contract. And of course, consequential economic damages, which, if they're foreseeable, you could also get under straight breach of contract. The other important thing that results from the court's finding that and holding that these companies are engaged in the business of insurance is that none of the EOCs or the policies contain attorney's fees provisions. As most of you probably know from working with insurance, is that you never find any insurance policy, at least in my experience, that has a written provision for the recoverability of attorney's fees. And if you then live with the traditional American rule that each party bears their own attorney's fees and costs, absent a written agreement to the contrary, you wouldn't, even if you prevail, you're not entitled to attorney's fees because there's no written provision. In California, at least, we had, before these companies were deemed by the courts to be engaged in the business of insurance, going back to 1981, California Supreme Court, in a case called Brandt, B-R-A-N-D-T, versus Superior Court, and later a case called CASSIM, C-A-S-S-I-M, versus Allstate, held that as a departure from the traditional American rule that you're not entitled to recover attorney's fees without a written agreement, the courts held that in an insurance case, we're going to have a different rule, basically for public policy considerations. That is that if an insurance company doesn't do what it's supposed to do when it's supposed to do it, then if you have to hire a lawyer to force them to do what they should have done, and they have been deemed by the trier of fact to have behaved unreasonably or in bad faith, then you get to recover your necessarily incurred attorney's fees as an item of consequential damages for the tort, only for the recovery of policy benefits. In other words, if you sue for $100,000 of medical bills that you were forced to pay out of pocket because the carrier didn't pay, and you then go to court and you recover the $100,000 plus the emotional distress of $500,000 plus punitive damages of $5 million, the case says you get to recover attorney's fees only for that what you paid to recover the $100,000 policy benefits. So it's not necessarily a huge thing, but at least it gives that additional benefit or remedy for a finding of bad faith. And then, of course, that amount of money is added in for the purposes of determining the multiplier for punitive damages if you recover punitive damages. The next slide here, I'm having trouble with it. So the technical person's, here we go, right to trial by jury. We know not only in the area of health insurance, but in consumer contracts generally, we know what's been going on in the courts, and the strong United States Supreme Court holdings supporting the notion that cases can be taken out of the court system and basically removing people's Seventh Amendment right to trial by jury and going into arbitration. And the HMO industry has not been asleep on that one either. The HMO industry has been very, very aggressive in terms of inserting more than any other part of the insurance industry. If you look at your automobile policies, except for UM or UIM coverage or your other types of insurance policies, CGL coverages, etc., rarely are you going to see arbitration clauses inserted. But in the HMO world, in California, for example, without exception, all of the major HMOs, Blue Cross, Blue Shield, Aetna, Cigna, Pacific Health Net, all of them, Kaiser, all of them have very, very stringent arbitration clauses. But we also then have a law in California having to do with what must an HMO disclose in order to enforce an arbitration clause. And that is then the next slide, which is entitled DMHC Plan, California Health and Safety Code Section 1363.1. Again, apologizing to the people who are not California practitioners, but drawing attention to it to see if you have an equivalent statute in your state. If you don't, we'll discuss some thoughts on how to avoid arbitration. But in California, at least, there is a statutory requirement that in order to enforce an arbitration clause, thereby barring someone from the right to a trial by jury, that it must be, and it's just basically a two-pronged requirement, that the disclosure must be prominently displayed in the enrollment form without defining what prominent means. There's no description of font size, etc., but it just says prominently. And then we'll discuss some cases interpreting these various provisions. And then also that it be displayed immediately prior to the signature line. So the notion is one of, you got to at least give them notice of what you're doing to them. If you're going to take away someone's Seventh Amendment right to trial by jury, you better do it with a prominent disclosure, and you better do it to where they don't read about it early on in the document, forget about it, and sign at the end, right above the signature line. Of course, before we leave that, the problem is, even in California where you have this law, which you'll see the cases on the next slide, a whole string of cases where we've been able to avoid arbitration by enforcing this law. The problem is that for anybody who does pay attention to what they're signing, which is rare in the first instance, but if you're a very sophisticated consumer and you're reading carefully the enrollment form and you're seeing, gosh, here I see this prominent disclosure in the enrollment form, and I know the meaning of that. It means I'm not going to get my day in court. I'm going to have to go to some arbitrator who oftentimes, in fact, in most instances in California, the arbitration company who's going to deal with the controversy is designated in the policy form so that you're now going to have your case heard by a company which has a contract with the insurance company who's denying your benefits in the first place. Not very comforting. And then they say, it's above my signature line, I'm not going to sign it. The bigger problem, of course, is that if you don't sign it and you turn in the form and you cross out the arbitration clause or say, I don't want that, you're not going to get insurance. And so you have a choice. As a practical matter, anybody who signs it, you have to sign it to get insurance. Your choice is to either sign it the way it is in this contract of adhesion, or avail yourself of the statute, not sign it, and then try to find a company who will insure you that doesn't have an arbitration clause. And if you live in California, you won't find any of the major companies that don't have an arbitration clause. So then the next slide is the slide which is case law, again, here in California, which this is all of these cases listed here. Every one of these cases, starting with Burks versus Kaiser, Imbler, Zalesi, these cases all relate to the failure of the HMO to comport with 1363.1. So again, unless you have an equivalent statute in your state where you practice, in which event the rationale in these cases would be helpful to you, these are not going to be of much benefit because these relate to California law. But in all cases, and if you don't have any equivalent statute and you're just dealing with an arbitration clause with no statutory protection or direction in your jurisdiction, it's still very important to look at the content of the arbitration clause. And every jurisdiction I'm aware of, in order to avoid arbitration, you have to demonstrate both procedural and substantive unconscionability. Most everywhere that I've seen, procedural unconscionability is determined just by the presence of a contract of adhesion. So if it's a contract of adhesion that was not negotiated, given on a take it or leave it basis, which these all are, you've pretty much satisfied that prong. The substantive unconscionability is also, it's in the conjunctive. You have to demonstrate both. And if that's what your jurisdiction says, then of course what you're looking for is things like, is the arbitration provision, that is the waiver of the trial by jury, is it bilateral? That is, or is it only purporting to take away the right from the insured but not from the insurance company? What's the allocation of costs? Are there provisions regarding the bearing of costs which are unfair? Where's the location of the arbitration? In other words, if you sell a policy to someone who lives in the southern part of the state, 500 miles away from where the arbitration is to take place, courts will ordinarily say that that's substantive unconscionability. So, in other words, even if you don't have a statute, you shouldn't just take it sitting down. You should challenge that, because at least our experience is that these cases have much greater value to the insureds if they're in a court of law in front of a jury instead of an arbitrator who has repeat business coming in from the same insurance company over and over and over, particularly here and in most jurisdictions the same. Functionally speaking, these are oligopolies, all of whom they compete aggressively for share of business amongst each other, but they all have mutually aligned interests in paying as little for medical care as they can get away with. And in a case where the same medical doctors in the delegated setting are providing care to patients that are simultaneously insured by 3 or 4 major HMOs, there's really no hope of fairness. So one of the particulars that we deal with then in these cases, and the next series of slides is going to try to illustrate some of the coverage issues that arise in what we call medical necessity review. And this is truly where the medicine and insurance collide in this setting. Because the reason for the tort, and if you're in a jurisdiction that doesn't yet have clear case law on this, the reason that the tort should apply to these companies, not only as strongly as it should against insurance companies, is because the special relationship is even more intense in this setting. Why? Because these companies are not just denying payment of money that's been paid out of pocket for care, and the failure to reimburse someone money, that's one thing. But instead, oftentimes in this setting, the decisions being made by employees of the insurance company or the company deemed to be engaged in the business of insurance are in fact delaying or denying medically necessary care, things that will cause death or harm to the patient. So if the company you paid premiums to not only is denying payment of money, but in fact is interfering with your medical care, then we believe that that's a more enhanced reason for requiring tort remedies. And there's basically three different settings in which medical necessity reviews take place. Prospective, or pre-certification, in other words, before the care is given. A concurrent review, which is typically limited to the in-hospital setting where doctor walks in, sees that the patient needs something, but knows they're a member of so-and-so HMO, so we better get consent and pre-approval to do this. So on a real-time basis, and then retrospective review where the care has already been given, oftentimes by in-network providers, that is, people that are under contract or have contracts requiring their services for patients where they've already given the care, and now their care they gave is being looked at with 20/20 hindsight by the insurance company. And of course, the parties involved, the next slide is parties involved in the medical necessity review process, are, of course, the insured, the subscriber, the treating doctor, the HMO or the insurer, so-called clinical reviewers, and medical directors. And medical directors in this setting, for the consumer, of course, what is the average consumer not knowing how this is all set up? Well, medical director is a doctor doctors are supposed to be there to help patients. But in this setting, of course, medical directors are people who they wear the hat of a medical doctor only to the extent that they have their name with a comma and the word MD afterwards, but the function they're performing is, in effect, benefit determination. And benefit determination of an insurance contract, an HMO contract, is another way of saying insurance coverage determination. And so they are doctors who are, in effect, making insurance coverage determinations. And before I leave this slide, for anybody who tries these cases, there are organizations that promulgate rules that apply to the standards of what's to be done, having to do with the timeliness and the accountability for these decisions. And I can tell you from personal experience that the rules promulgated by the National Committee of Quality Assurance, referred to as NCQA, are a treasure trove of good things for a lawyer representing a consumer. You could fashion your jury instructions right out of the standards, and you can use these against them because all of the major companies advertise to the world that they are accredited by the NCQA, the gold seal. It's the good housekeeping seal of HMOs. And so we're accredited, and we get the award every year for being the top banana, whatever, NCQA. And if you pull these rules, for example, for a delegated model, when the insurance company delegates to a contracted medical group the function of providing the promised care, the industry would tell you, we're not doctors, we cannot practice medicine, therefore we have to contract with doctors to provide the medicine. What they don't tell the people is that in the contracts that they have with those so-called independent physician association or IPAs or PMGs, the participating medical groups, whatever the acronym they use, in those agreements, they take the insurance premium dollar in at the top to the HMO, and then they enter into contracts where they take, on average, 80% of that money and funnel it down to the doctors, keeping 20% for overhead, executive compensation, and advertising, and publishing the book of promises. But they delegate all the responsibility to the doctors to provide the care and on a capitated basis in that delegated model. If you have a case like that where the care has been given by the Physicians Association, what they don't tell people is that the limited amount of money that goes down that the risk has been shifted. The entire financial risk of maintaining the health of those patients who paid their premiums to the insurance company has now been delegated down to the IPA. And again, in California, we got some bad law that came down on that, having to do with basically traditional notions of severance of liability, that the HMO, that the conduct of the IPA, that the liability is severed, that like a traditional notion of independent contractor. But if you don't have a practice in a jurisdiction where that's a problem, I think that there's a tremendous argument that that's a non-delegable duty, and that the nature of the work being done is inherently risky, and that it should be non-delegable. You shouldn't be able to take in the money, make the promise, and then delegate out the responsibility and the risk. And the other thing that the NCQA does is it promulgates very, very strong rules on timeliness, and they're for routine requests for care, for urgent requests, all very tightly defined, and almost invariably the HMOs fail to comport with those timeliness requirements. And in such a setting, even if you're in a jurisdiction which cuts off the liability for the medical care and puts it just with the medical provider, which of course in California has substantial implications because of the caps we have on damages against doctors. Some jurisdictions it wouldn't matter if you don't have any caps. But nevertheless, if they're not complying with the timeliness requirements, then you can make direct allegations against the HMO for direct liability, non-vicarious liability, for not having proper oversight of their obligations are to oversee the performance by the delegates, and that's also contained in the NCQA standards. Examples in California of what should a carrier take into consideration in making a medical necessity determination. The next two slides are cases that we had going back to the 80s in California, which have wonderful language. Sarchet was a case tried here in a local court by my partner, Bill Chernoff, and California Supreme Court came out with this. When pre-admission screening is not feasible, we think the best the courts can do is give the policy every reasonable interpretation in favor of coverage. We trust that with doubts respecting coverage resolved in favor of the subscriber, there will be few cases in which the physician's judgment is so plainly unreasonable or contrary to good medical practice that coverage will be refused. So we thought that was wonderful language when our Supreme Court came out that in 1987, but that has been universally disregarded, and we've had a great deal of difficulty of getting the courts out here in California to pay any attention to that, because it just became so prevalent that the HMOs were going to do their own review, oftentimes what we call just a paper review, where some medical director is on a computer screen second-guessing the opinion and the request for care given by treating physicians without even talking to them, without even trying to. And so, but that is the law, and I don't know what it is in these other jurisdictions, but it's worth looking at Sarchet. The other decision is Hughes. 2 years later, it was an appellate court decision out here, basically holding the same, and these were against both of the major HMOs, Blue Shield and Blue Cross, which in California are not part of the same company. They compete with each other. But now then, we have a series of slides where we show you some samples from actual coverages. And so the evidence of coverage, what is covered, the grant of coverage, and I guess before we go further, because they're engaged in the business of insurance, the rules of construction of an insurance policy should apply. That is, that grants of coverage should be liberally or broadly interpreted to provide coverage, and exclusions or limitations on coverage should be narrowly construed. And so we believe that, at least here in California, and I think most jurisdictions have similar rules of interpretation of insurance contracts, that the weight of interpretation is in favor of the insured and against the insurance company, mostly because of the rules governing the interpretation of contracts of adhesion, which are drafted by companies which are in superior bargaining position and are supposed to have superior expertise. And so the grant of coverage for medical necessity says this agreement only covers services and supplies that are medically necessary. And of course, all of these contracts are all risk policies where it's not a question of really what's covered, it's really a question of what's excluded. In other words, everything that you need for your health is covered unless it's excluded. And if it's excluded, it has to be excluded in a clear and concise and unambiguous fashion. And then it says, please refer to the definitions for a definition of medically necessary. Okay, so it says we're going to pay for things that are medically necessary, but we're not going to tell you here what that means. You're going to go somewhere else to figure that out. And so then we go to the definition. And the definition of medical necessity or medically necessary medical necessity, and you'll see our services, procedures, treatments, supplies, devices, equipment, facilities, or drugs, all services. So you see it's very broad in the coverage. That a medical practitioner exercising prudent clinical judgment would provide to a member for the purpose, and let's pause there. And in California, at least, that prudent clinical judgment will be tested against the standard or should be tested against the standard enunciated by the Supreme Court in the Sarchette case, having to do with basically, unless what the doctor is recommending is below the standard of care and is plainly unreasonable, then it should be paid. And then it goes on and it sets up the prongs in accordance with generally accepted standards of medical practices, clinically appropriate, not primarily for the convenience of the member, in other words, like elective cosmetic surgery. But this last one is important, not more costly than an alternative service or sequence of services, at least as likely to produce equivalent therapeutic or diagnostic results. Now, the reason we included this here is because on a given case, you need to look to that which is being denied measured against the definition that's in the policy. And nowadays, many of the policies have this final component of the cost right into it. And there, of course, examples of where we've run into issues or problems there is that there are certain diseases for which there are a variety of treatment modalities, all of which are within the standard of care. For example, prostate cancer. We fought the battle of prostate cancer here in California 20 years ago because there was a local hospital, Loma Linda University Medical Center, had a proton beam machine that back then cost a lot of money. I forget what the number was. It was a big machine, very expensive, and it was very effective for cancers that required pinpoint precision of a tumor in the brain or whatever, but also for prostate cancer. The notion was that with this beam, you could go in and focus on the prostate gland. You could stop the beam at the back end of the prostate so it didn't do any collateral damage beyond the gland, and you didn't do anything on the adjacent organs and tissue. So it's basically a rifle rather than a shotgun. But the literature, even to this day, upholds the idea that external beam radiation is also within the standard of care for prostate cancer. Radical prostatectomy is within the standard of care. Proton beam, now is also, but so then this kind of a provision would allow the carrier to say, hey, I can get Dr. Jones, who's been doing old-fashioned radical prostatectomies that leave you impotent and incontinent, but nevertheless get rid of the cancer. That's still within the standard of care, and we can get that done for a lot cheaper than we can get proton beam. And using that definition, they could probably get away with it. And so you have to make sure that when you have the doctor who hopefully is being an advocate for the patient, the doctors need to be provided these definitions of medical necessity so that when they appeal from the denials, they can use these buzzwords and they can explain why in their appeal letters, that they're able to satisfy the requirements. And then the EOC definition of medical necessity is the next one. Credible scientific evidence published in peer-reviewed medical literature. And so when the doctors are appealing from these denials, almost invariably the doctors, the medical directors, and the clinical reviewers making these decisions to deny care are not putting in the reasons, and they're not providing the insured with any backup, so that when you appeal from them and you have a doctor who's going to be your witness in terms of why his patient or her patient needed this care, it's best that they give the information that's contained right in their own book. So you can say, hey, look, they never told me, they didn't give me any proof of why it wasn't medically necessary, yet our treating doctor, Dr. Jones, laid out for them chapter and verse why it was medically necessary. And then policy exceptions, reductions, or limitations, or commonly referred to as exclusions, must be narrowly construed. And we gave some case law in California on the rules of construction, which apply to insurance companies. And then in California, again, Health and Safety Code prescribes statutorily that these exceptions, reductions, or limitations have to be contained in the EOC in concise and specific terms. And this is important because what we're finding, as we'll show you for the next slides, is that oftentimes the carriers are using documents or medical policy provisions that are extrinsic to the EOC to support denials. We'll go to the next slide. And then this is a sample Blue Cross denial letter in a case we recently did having to do with a particular spinal surgery. It was a neck surgery for a retired professional baseball player. And they then cite we base this decision on the health plan medical policy, cervical total disc arthroplasty. And I underlined that and highlighted it here because it's our contention that you cannot do that. If you're not going to pay for something, you have to rely on the language in the EOC. And it's an exclusion, then you got to put it in the EOC. It's got to be clear and concise in order to comport with the law. And these companies, all of them have these external medical guidelines and policies. And these external guidelines are not part of the coverage, and therefore either are A, unenforceable, or if they are tantamount to an exclusion, then they need to be included in the policy. Let's go to the next slide. Now, we also looked at that same EOC trying to, scrutinize it, devil's advocacy. Did they refer to it? And the answer is yes, they do. They say, we will use our clinical coverage guidelines, such as medical policy and other internally developed clinical guidelines, procedures of preventive care, clinical coverage guidelines, to help make our medical necessity decisions. So they, in fairness, they do disclose that they're going to use it. But then they say themselves, And it's not us making the argument that they need to put it. They say your agreement takes precedence over these guidelines. And so the agreement they're referring to is the evidence of coverage agreement. And that agreement says they're going to pay for everything that's medically necessary. And no matter what their extrinsic document says or their policy, if you can prove through your expert or your treating physician or both that it's medically necessary, then by their own language, it trumps the, pardon the word, use of the word trump. An example with cervical artificial discs. Let's go to the next slide. This is an example of an extrinsic medical policy dealing with this particular, and by the way, this is one of, just for this one insurance company, one of several hundred, if not 1,000, medical policy guidelines that you can find online. This one's numbered Surgery 00055. So a tremendous amount of effort and resources gets dedicated by these companies to reviewing on an ongoing basis these procedures. But it's doctors in a setting, in an academic and a clinical setting, figuring out what they're going to pay for, what they're not going to pay for. But they're not people that are experienced in knowing how you must then present this to the consumer in the insurance contract. And then let's go to the next slide. This one deals with, you can see that all of the hoops you'd have to go through to make a determination of medical necessity. Implantation of a brine, cervical disc, all the way through, and then everything that you would have to prove to be able to capture coverage. Next slide. And then it defines investigation and not medical necessary in the EOC. And we put as an example hybrid constructs in a single procedure involving cervical total disc or arthroplasty is not medically, if they put that right in the policy. Now that one, if you went in and your doctor says, I want to have a hybrid construct in a single procedure with cervical fusion, it's excluded. So they would probably be able to enforce the exclusion. But in fact, in this case, next slide, they went through and they decided that revised investigation non-medically necessary to other devices at more than one spinal level. They have the revision date 2013. Next slide. They then come up with a medical policy that position statement, investigation non-medically necessary, cervical, artificial, intervertebral discs are considered investigation non-medically necessary. It was our position in that case, which later resolved in favor of the subscriber, that because they had already made the determination that in all settings it was investigation non-medically necessary, that would have had to been put into the policy, as was the other one, to enforce the exclusion. And then, of course, in most jurisdictions, they're required to use people who are qualified. We've had experiences where out here very complex cancer cases were being reviewed by OBGYNs and people that were not even licensed in the same area of practice. And so here in California, we have 1367.01 of the Health and Safety Code, and I think there's equivalent statutes in most jurisdictions that require doctors to be competent in the precise area. So in every case, you need to look to the qualifications of the doctor, particular doctor who's making these determinations and sending out letters denying benefits because of medical necessity. Because the single most common reasons for denying medical care in the HMO world is so-called medical necessity or investigational and experimental. That's where all the fights are. And of course, we just recommend the things to look for is before they denied, that the medical director that made sent the letter denying the care even attempt to contact the treating physician to say, hey doc, why is it you're referring, why are you recommending this? At least capture the reasons from the treating physician, because if there is an implied covenant, if there is in all jurisdictions that I know of that have the tort of bad faith, then you're required to give as much consideration to the insurance, to the interest of the insured as to the interest of the insurance company, and to conduct a fair, balanced, and thorough investigation. Then at a minimum, that would require at least talking to the doctor before you deny and tell the patient that which Dr. Jones, your treating physician, recommended for you is not medically necessary. I mean, think about that. What must that feel like for a patient to be told that their own doctor is doing something or recommending something that's not medically necessary? The independent medical reviews, here in California at least, people are entitled to have it reviewed by a third party before a final determination is made. Again, this Mintz case we cite here for any California practitioner is important because many of the public employee contracts, for example, with the CalPERS system in California, Public Employee Retirement System, judges, for example, when they buy what they think is Blue Cross coverage, they really are buying CalPERS coverage. It's a self-funded plan with a third-party administrator, namely Blue Cross, who is charged with the responsibility of administering the plan, but they are not in privity, that is, the beneficiary or subscriber is not in privity of contract with Blue Cross. They are in privity of contract with CalPERS. And so then the argument is you can't sue me for bad faith if I'm an insurance company and I'm not in privity of contract with you because it's not my money. And actually, Mintz at the trial court level got blown out on that argument. Then we did the appeal. Mintz was a judge who's now deceased, but we were able to keep Blue Cross in on a negligence theory on the grounds that their denial of the care, even as a third-party administrator, that it was foreseeable that it would cause harm to Mintz. So that's a way around that problem of lacking privity. And then recently, we've discovered that some of the major companies, for example, Blue Cross does their own reviews internally. They have Anthem has a branch of the company that deals with nothing but medical necessity review, in effect, in-house. But Aetna and Cigna also, which have large market penetration around the whole country, they contract with a third-party Wall Street company called Med Solutions. And any denial for medical necessity by Aetna and Cigna, for example, was probably done by this company called Med Solutions. And those contracts, it's very important to get your hands on those contracts because of certain incentive agreements, financial incentive agreements having to do with sharing in the benefits of the denial of the care. So that's it. And she told us that we should open it up for questions if anyone has any questions they'd like to ask.
Yes, thank you so much for your presentation. We will now open today's program up to question and answers. You can submit your questions in writing by typing them into the Q&A pod, and we will pause for just a moment to assemble a queue. Okay, it looks like we have the first question here that came through. It says, can you provide more information regarding the NCQA rules you mentioned?
Well, they're about, if you order the book, you can go online and get it. And if anybody, I'll give you my email address right now because then we can send you a link. It's mbidart@chernoff.com. In fact, I see it's on the screen here. And then we can send you the information on how to get it. But the NCQA guidelines I'm talking about are about 1.5 inches thick. There's a whole series of them. So, but it's very powerful information. So we'll be happy to help anyone who's interested get that information. We have the book here, but rather than send you our book, we can tell you how to get it.
Great, thank you. And we will pause and see if are there any other questions that come through. Looks like the next one here, what does NCQA stand for again?
The National Committee of Quality Assurance.
Great, thank you. Okay, and another question here. How and what stage do you most commonly identify these types of cases?
Stage or state?
Stage.
Okay. In our experience, most of the cases that come to us have had the first level of review by a medical director, and there's a denial letter that's been sent to the subscriber and the treating doctor. That's when we normally get them.
Okay, great. Thank you. And another question here. Are you or do you know anyone litigating medical necessity cases against auto insurers, either first-party auto claims, MedPay, UIM, etc.?
We've had very small experience ourselves in that because normally the benefits are so small under the MedPay provisions. But, we do first-party auto stuff as well. But depending on the coverage provision, what's been denied, oftentimes it's a $5,000 or $10,000 issue.
Great, thank you. And the next question, in the delegated model you discussed, where the IPA makes the medical necessity decision, what other causes of action besides negligence may be available?
In our experience before, if you look at just for, even if you're not a California practitioner, but you just want to read up on it, you should read a case called Watanabe, WATANABE versus Blue Shield. And a case that was our case, Martin versus Pacific Care. Martin versus Pacific Care was a heartbreaker because my partner, Ricardo Echeverria, was in the middle of trial on that case. It was going really well, as later evidenced by the conversation with the jury. But in the middle of the case, the Watanabe case came down, and the court had to dismiss the case against the IPA. But breach of the implied covenant, if you're in a jurisdiction that doesn't prohibit the claim against the IPA, you'd have breach of the implied covenant against the HMO and breach of contract for the express covenant in the contract at a minimum.
Okay, great. Thank you. And another question here. Do you get involved with the review process, helping the doctor provide better arguments for medical necessity?
Yes, any chance we get. We want to definitely do the things we were recommending earlier, where we now try to perfect what the doctor may not have done already because they just don't know. They're doctors. They don't know what the coverage requirements are. So we get the patient or the client comes in, they have a denial letter, we look at their EOC, we look at the nature of the care being requested, we look at the denial letter, we say, let's improve upon this, let's give them another chance. In other words, normally, just give them a little more rope to hang themselves. We definitely do not do it on our letterhead. We don't make ourselves a witness, and we're just trying to perfect the bad faith claim at that juncture before we then move in. So the answer is yes, we do. But unfortunately, many doctors are reluctant to deal with lawyers. There's this natural, antipathy, and it's a shame because we're all trying to help the same person, but it's oftentimes difficult to get cooperation. So we normally use the patient themselves, and we give them instruction on what to go get for us from the doctor.
Okay, thank you. And it looks like the same person who asked the previous question followed up with as a ghostwriter for the doctor. Is that?
Yes, that's exactly what I mean.
Okay, great. Thank you. And it looks like that is all the questions that we have at the moment. So we will go ahead and conclude our session. I would like to thank our speaker for his participation and thank all of our registrants who attended today's program. Your certificate of attendance and evaluation form will be emailed out to you within 24 hours. And we ask that you take a few moments to provide us with your evaluation of today's program. And it looks like Michael, we had one more question come in if we can grab it before we leave. It says, can you describe the IPA a bit more?
Yes. IPA stands for Independent Physicians Association, and really the advent of IPAs, at least in California, was as a result of the increased market penetration of HMOs. In other words, in order to, as a doctor, a general practitioner, for example, in order to get patients, you had to get involved in contracts with HMOs because they were going to direct or steer patients to particular doctors. And they're not going to send them to doctors they don't have a contract with. The essence of the managed care model is that they know how much money they're taking in premiums. They need to be able to deliver the promises they made in the EOC for within the budget of the premiums they take in. And so they work backwards from the amount of money they have. That's why, managed care sounds like a very benign term, but it's really rationed care. But that's what managed care is all about, the rationing of dollars.
Great. Thank you so much. So with that, I would like to invite everybody to check out our next Seminar Web Live program, which is tomorrow's ABOTA Masters in Trial, a trial demonstration from opening statement to jury deliberation. I invite you to visit your association's website for a list of more upcoming programs, and have a wonderful day.
Thank you.